Welcome to Case by Case. This is a podcast brought to you by Zyla Floyd Zadkovich. This is Luke Zadkovich, one of the co-hosts, and with me is Calum Chain. How are you, Calum?
I'm very good, Luke. It's good to be back.
It is good to be back. It is good to be back. This series is an exciting one for us because we're branching out, so to speak, and inviting friends and colleagues and contacts in the industry to join us. And today I'm very excited to introduce Adedoyin Afun, a partner from Bloomfield LP in Nigeria. Welcome, Adi.
Good afternoon, gentlemen. Thanks for having me.
It's our pleasure. No, we're excited. You're the first guest we've had outside of ZFZ.
Oh, that's exciting.
I'll just say a couple of words about Mr. Fun just to introduce him. Adi's a leading maritime and commercial lawyer solicitor in Nigeria. We've had the pleasure of working together on a number of matters over the years, and I've got here in front of me a bio with many accolades and awards and things that Adi's achieved. He's been described as one of the leading lawyers in Nigeria for maritime, in the oil sector, aviation industries, and others. He's ranked with Who's Who Legal, in Legal 500, and other articles. He's a Nigerian barrister and solicitor, also qualified in England and Wales, which is going to be good today because I think the decision that we're going to discuss, which is a Nigerian, is going to lend itself to a bit of comparison. And also Adi's on various committees, a list too long to read out here. And notably, he's the chair of the Maritime Committee on the section on business law with the Nigerian Bar Association. He's also a member of various English organisations as well, like the LMAA and Association of Average Adjusters and others. And I can see here that Adi works in fields beyond maritime as well, even though that's the focus of today's talk. So with those words, welcome, Adi. What have you brought to the table today to discuss? What's the case that we're going to look at?
We're going to be looking at the Sam Popo's case. It's a decision on the Nigerian Court of Appeal. I thought it would be a good way to kick off the new year, considering the importance of seafarers to the world and COVID last year and possibly going forward. It touches about the rights of seafarers to claim for their wages from a Nigerian law perspective.
Yeah, look, I think it's a great one. I really do. And for those of you who are just joining us and haven't listened to prior case-by-case episodes, what we do is we get a case. We don't talk about the case before we jump on the podcast. We read it each individually and come to the recording with our own views. And we've done that here. Calum, Adi and myself, we've not discussed the matter at all. So yeah, it's a fascinating one, and I'm not sure I ultimately agree with the decision, if I can say that from an English position. I'm really interested to hear your views on it, Adi. But it's good to have, I dare say, a controversial case to talk about.
It's exciting having something which is controversial, but also it's one where, from an English law perspective, in some ways it's hard to fully agree or disagree because we've got a kind of iceberg of the Nigerian constitution, which gets in the way of the Titanic of kind of the ordinary commercial way of doing things. And from an English law perspective, it's very rare that we have to deal with those kind of constitutional questions. And that's what makes this judgment, I thought at least, so fascinating.
Yeah, I like that. I'm not sure where that leads, an iceberg and a vessel. We look back at history, but it sounds like we might have a collision course during this recording. So perhaps where we could start, Adi, is if you could give us just a short rundown of the facts of the case and what it's about in kind of broad terms, and then we can get into some of the nitty gritty of the decision.
Okay. Whilst preparing for this, I remember that this vessel has a lot of history, and I thought to just give a brief overview of that before we go into the facts of the case. The vessel is known as MT Sam Popo's, which is a vessel that has had various ownerships, ranging from a member of the Tushan group in India to a Bebo charterer that is out of the Cayman Islands, to another subsequent owner that was in the BVI owned company, to a subsequent Marshall Islands registered vessel. In between all this, the vessel was also subject of finance, sale and leaseback in Norway, with Fenley putting that together. And eventually the vehicle that owned the company was put into bankruptcy. As I understand currently right now, there's even still a case on wrongful arrest in the Singapore High Court. So it's not just Nigeria alone, there's a touch on this particular vessel. But the case we're talking about today is in relation to a claim for crew wages which commenced sometime in 2017. Whilst the SAM purpose was in Nigeria, I think our bareboat charter was terminated by the owners. The bareboat charter then was a transpurpose, the Transnav, it's like an Indian group management company. And with that, there were several arrest orders attached to the vessel from suppliers engaged by Transnav, as well as a repossession order from the owners. So that means the crew was stuck in Nigeria for a lengthy period of time without anybody really taking a responsibility for their maintenance. On the back of this, they instructed counsel to arrest the vessel as security for the outstanding claims. The claim went before the Federal High Court of Nigeria, and counsel to the owners and the vessel sought to set aside the arrest order on the grounds that the Federal High Court of Nigeria, which is the first court of instance for admiralty matters pursuant to our constitution, does not have jurisdiction to hear the matter because it touches upon a labor dispute. Now, Nigeria has a specialized court that handles labor issues. This is National Industrial Court. And it was an interesting objection to raise. Interestingly, this is not the first time we've seen that in this market, but this was the first time that this argument went on the grounds or the ways we're going to discuss. The court of first instance, the Federal High Court, interestingly, the judge who heard it was a former seasoned maritime practitioner before he went on the bench. And he probably took an absurd view to it that this cannot happen on his watch. He listened to the arguments and held that because the Nigerian labor law, which was incorporated in the constitution, provides that matters concerning crew is not within the purview of the Labor Act, which forms the ground known for the National Industrial Court. He declined and said that he had jurisdiction, and the matter went on appeal, and that's what we'll be discussing today. That's a brief overview.
Yeah, so just pausing there, and if I may, and just kind of give a high level take from my perspective. What we have here is we have a kind of clash of different jurisdictions within Nigeria. So you've got the labor employment jurisdiction, which is the purview of a certain court. We'll come on to that in a moment. And we then have the admiralty jurisdiction, which is dealing with, maritime liens, maritime claims. Ordinarily, we would think that a claim for unpaid wages of crew on board a ship would be within a maritime claim and one that you'd have a maritime lien for. But what we're looking at is this kind of clash between two different jurisdictions and which one should win out. And the first instance decision, as Adi's explained, with a seasoned maritime judge, a practitioner, now judge, has gone the route of that a claim for unpaid wages is very much a maritime claim. It's within admiralty jurisdiction. And then the challenge to that was brought and lost in first instance was that no, the labor court, or is it the National Industry Court, has exclusive jurisdiction over all matters relating to labor and employment, including claims for unpaid wages. And that challenge was dismissed at first instance, and then the respondents, they then appealed that decision. And in this Court of Appeal decision, which was before 3 justices, and the decision was issued in March 2021, there was the appellants won, to give off to be a spoiler or what have you. And the appellants ultimately won, and the Court of Appeal went the opposite direction to say, well, no, this is the exclusive jurisdiction of the labour courts, and quite surprising, I think, from a foreign perspective. And then I suppose it's a matter of getting into the reasons for that and how compelling we may or may not find them.
And I think maybe this is, I mean, Adi, correct me if I'm wrong, but it struck me that the argument, the core argument that was raised by the respondents who were ultimately successful was that under the Nigerian constitution, these national industrial courts have exclusive jurisdiction over any labor disputes, whereas it's under a separate body of law that sits outside the Nigerian constitution that you have the law that gives the High Court the admiralty jurisdiction over crew wage issues. And the respondents recognized that there was this other body of law, this other legislation that said that there was admiralty jurisdiction for crew wages in the High Court. But their argument was that's overruled by the Nigerian constitution.
Well, I think it was a bit of taking a step back. We always need to look where we're coming from before we know where we should be going to. The Admiralty Jurisdiction Act was enacted in 1991, and that's where you set out all the admiralty jurisdiction of the Federal High Court. Prior to that, the Nigerian Constitution sets out specifically in Section 251 that the admiralty jurisdiction is within the Federal High Court of Nigeria. A few years after that, I think the International Labour Organization wanted Nigeria to create a specialized court for labor matters. And for some reason, most maritime practitioners I've spoken to just took their eyes over the ball when that part of the Constitution was being amended. And what they wanted to do was to ensure that all labor matters, particularly those flowing from the Labour Act, will go to the specialized courts. Now, the Labour Act itself recognizes that crew and aviation-related labor matters are not within its purview. But the drafters, without looking at all this history, just put in language that says, notwithstanding any other provision of this constitution, all labor matters are vested with it. Now, having said that, we all know historically, internationally, that maritime crew wages attract a maritime lien. Now, the NIC, which is the labor court, has no right to grant an arrest order. So you can see the dilemma. It wasn't an intention of the draftsman or the legislators to take this maritime jurisdiction. So it was those language, and then we go into the realms of interpreting constitution and whether it was done rightly or wrongly. And I think that is where the ultimate appeal to the Supreme Court, which I understand is in the pipeline, would end up being decided upon.
It'll be very interesting to see what the Supreme Court says, because one of the points that I thought was fascinating reading through the federal court decision and then the Court of Appeal decision was the point that you've just made there, Adi, which is that if this is correct, and if it's correct that all of any crew arrest issue for unpaid wages effectively has to be put before the national industrial courts in Nigeria, then the practical effect of that is that it's hard to see a way that it would be possible to enforce an arrest for crew wages in the Nigerian jurisdiction.
Yeah, so owners and managers are very happy.
Yeah,
I was talking to a colleague that does a lot of this. He's basically said he's had to transfer a lot of his cases from the Federal High Court to the National Industrial Court, and he knows that owners will just take their time because they have no arrest, no bank guarantee that will make them pay on time or reach an amicable settlement to get it out of court. It's a shame, though, right? I think, and what we're also trying to do within the maritime community is to get the Supreme Court to bring back what they used to do before, like an amicus, where you get a third party not related to the claim that can provide basis and reasons for them to consider and reaching a decision. And I think it's also a reminder of the times we are in Nigeria and what the Nigerian Maritime Law Association as well as the National Judicial Institute are doing. We did the first training for judges strictly for maritime last year, the privilege to be part of that. And one of the things we talked about was issues of this nature as well as piracy. And the second one will be coming up. And Maritime is a very specialized area. These judges don't have that experience, so we need to give them information to guide their position.
Yeah, well, you answered one of the questions that I had, is whether this is being appealed and how far along in the process that is. What I found interesting, and this was, I suppose, more of a stylistic point, is how skeptical or how harsh some of the language was on the submissions that were being made for the respondents on the appeal. And the court did not seem interested at all in exploring the territoriality limits of the jurisdiction of the NIC. And I can see where the advocate was going on that, to say, well, is it intended that the Constitution of Nigeria, in setting out an exclusive jurisdiction for employment and labor matters, is intending to venture into international labor issues? You can imagine a situation like this where you have an international crew. The crew are performing services outside of Nigeria. They're not Nigerian. The ship is not Nigerian. There's next to no connection with Nigeria from an employment perspective, other than it calls in Nigeria. The language that was contained in the judgment was quite scathing of some of the submissions that went down that line. And I'm not passing any judgment on the nature of those submissions, but the court wasn't interested in it at all. And when I went myself to then look at the relevant provision, in section 254C 1 and 2 of the Constitution, this is the 1999 as amended version, and most of the focus was on section 1 or subsection 1 of that section. But there is also subsection 2, and I wondered whether you'd had a chance to look at that, Addy, because it's a provision that confers more jurisdiction on the NIC, but interestingly, and the jurisdiction is conferred with respect to or pertaining to the application of any international convention, treaty, or protocol of which Nigeria has ratified relating to labor, employment, workplace, industrial relations, which makes a lot of sense. But it is, as I can see it, from those two subsections, the only aspect of this that seeks to deal with the international dimension of employment-related issues. Now, I don't think that maritime employment issues are necessarily falling within subsection 2, but the language in this provision is not about exclusive jurisdiction. It's just the granting of jurisdiction and power. And it seems to me that there is an argument to be made around where is the limit of the exclusive jurisdiction of the NIC with respect to national versus international issues. And it didn't really come out in the judgment. But I wanted to know your take on that, Addy, and in particular, what do you think will be the main lines of argument for now the appellants in the Supreme Court?
Well, Luke, I must say you have a crystal ball. That's why I love working with you. The issue you just touched upon is one of the issues. I've seen a draft of the leave to appeal to the Supreme Court, and that touched upon that. Notably, I think, like I said earlier on, this is not the first time this argument has been raised before the Federal High Court. In the case of the Pokai Son, sometimes in 2005, I acted and that for the owner of the vessel. And there was a crew element to it, and this was raised. And interestingly, the current Chief Judge of the Federal High Court was one that gave that judgment, and he said that he gave the distinction that if you're Nigerian, these are not Nigerian crew members. In this particular instance, the crew or the Sanpopos were Indian employment contract provided for, I think, Indian law or something like that. And that is what the counsel sought to distinguish. That, look, my lord, there's a judgment of the Federal High Court which provides that if they're not Nigerians, this was not applied to it, but they didn't even consider it. So it's one of the grounds for his appeal that the Court of Appeal erred by not considering that aspect. More importantly, since the Constitution that they are seeking to grant jurisdiction upon the NIC is more relatable to Nigerians. That part 254 C Part 2 was put in there and has been used by the NIC to ensure that Nigerians get the benefit of international best practices. You know, under Nigerian law, if a convention is not made our law, that means domesticated, it has no force of law in Nigeria. But the NIC has been able to use that 254C to bring in international best practices that not even yet domesticated into Nigerian law. So, as I said, it's one of the grounds that I've seen. I think it forms about 2 or 3 grounds of the appeal for the Supreme Court.
Mm. Yeah. Fascinating. Coming back to a point of procedure on this, can you, and picking up on your comment, from a colleague of yours who's handling a number of these types of claims, and they've now been transferred over into the NIC, and Callum's point about, well, if these types of unpaid wages claims fall within the NIC, then there may be a procedural lacuna around getting an arrest order for these types of claims under maritime jurisdiction. Is there some type of process by which you could bifurcate the substantive employment-related claim, which may be, as matters rest at the moment in Nigeria, the jurisdiction of the NIC, with the more procedural application seeking a writ of arrest?
Well, it's an interesting point. As you know, as lawyers, we always try and find everything wherever we find ourselves. I have my own theories. We've internally in my firm, we've put together our own case strategy in this regard. The Nigerian Industrial Court has a right to grant attachment. Some people believe that you can get an attachment over a vessel, and that is not necessarily going into the Admiralty jurisdiction. The Court of Appeal decision rules that what the Court of First Instance said, that the way the claim was couched, it does not fall within the what is deemed a labor matter under the Labor Act. Now, considering that, the Court of Appeal also said that jurisdiction will vest based on the plaintiff's claim. So I personally believe you can couch your claim to fall within the jurisdiction of the Admiralty Court, and you will stand the test of time to get an arrest order and sustain it. Now, from a strategic point of view, you also have to consider whether you want to do a try and test with that particular claim or some other one. But there are theories as to how you may be able to bifurcate it or use the Nigerian Industrial Courts to get the all-powerful prejudgment security by virtue of some kind of injunction and have them post some security. So those are things people are still considering. For those that currently have cases before the Federal High Court, you will just want to find a way to either discontinue your suit and start a fresh one in the Federal High Court in NIC with a view to trying the attachment, or you just get your matter transferred there too and just continue in person without any security or any in-rem access connected there too. So it's still open seasons, but I think there's 1 or 2 people have tried it, and we'll just have to wait it out and find out what the courts say about it.
It sounds like one of those situations where you have a defining judgment, and swiftly following up on that defining judgment, you have an entirely new approach to dealing with the same problem, which then expands the law in some way. I wondered as well, I noted that there have been a few different Nigerian constitutions across the last century or so, and this one was most recently amended in, I think it was 2011.
Yes.
Is it if there's a kind of backlash to this decision from the maritime community and the NIC feel like, perhaps the jurisdiction they're granted by the Constitution as drafted is too broad, is there any feasible possibility of the Constitution being tailored to resolve this issue, or is this now a problem that the courts will find a different way around to avoid impeaching on the Constitution in any way possible?
Well, I think maritime practitioners are looking at it from a 2-pronged angle. There's opportunity for you to submit a private bill to get this amended, but constitutional amendments have very high thresholds, which is almost difficult to achieve. So the more sure angle is the Supreme Court, who can do and undo, and there's no appeal from that level. So yes, I can confirm that Nigerian Maritime Law Association, as well as other practitioners, are engaging members of the House of Representatives and the Senate to consider this amendment as part of certain other amendments to the Constitution that they're trying to put forward a case. We've done that. We've also engaged the Federal High Court to let them know that it is a derogation of the Admiralty jurisdiction if they don't sit up to it. Today it is just a maritime wages for crew members. Tomorrow it might be something else. So they need to put forward the history, and that it was not the clear intention of the legislators to remove from their jurisdiction. And we're just hoping for the Supreme Court. That's why we're all trying to rally around to explain to the Supreme Court and let them see reason, and then that becomes the law by virtue of case stated as the highest authority.
And the Supreme Court is obviously a body capable in Nigeria of interpreting the Constitution and giving effect to it in a way that also makes sense in the context of the maritime community and the maritime history around crew wages and maritime arrests in respect of those crew wages. So I guess when the maritime community is hoping for the Supreme Court to kind of come to their aid, is it fair to say that what they're looking for is the Supreme Court to give effect to the concerns of the maritime community and find a way through this difficult legal situation that recognizes the historic admiralty jurisdiction of the federal court?
Yes, I think also there's also case law to back that up, more from an interpretation of the Constitution. There is a Supreme Court decision that says that when there's a conflicting provisions of the Constitution, or there's no clarity as to the simple and literal meaning, then you shouldn't use the simple rule. In this particular instance, it's clear that the argument that the words "notwithstanding any provisions of this agreement," in the same Constitution, it states that the Federal High Court has admiralty jurisdiction, and then the admiralty jurisdiction of the Federal High Court is then set aside into an act. So the Supreme Court should be able to resolve it under case law to say that intention of the regulators and not intention of that word notwithstanding to mean that 251 we preceded 254 or will take precedent over 251.
Yeah, this was a point that I thought was very interesting because it was argued extensively by counsel for the respondents in the Court of Appeal, the ultimately successful counsel, that the basis on which the Admiralty Court, or the basis on which the federal court has jurisdiction over crew wages is through the passage of an ordinary law, but the basis for the NIC to have jurisdiction over that dispute is through the passage of the Nigerian Constitution. And it seemed like that argument ultimately got them home.
Well,
but at the same time, sorry, go ahead.
No, I don't think I know that argument was made, but I don't think the respondents did a good job on it, because 251 grants the Federal High Court with admiralty jurisdiction.
Well, exactly. This is what struck me is that actually it's not a conflict between the Nigerian Constitution and a secondary piece of legislation that's subordinate to the Nigerian Constitution. It's a conflict between 254C and 251 of the Nigerian Constitution, because it's so clear that the admiralty jurisdiction encapsulates the crew wages element.
And to add to that, I think 251, because it was later in time, and the sponsors of the bill were able to provide clear language. If you notice, 251 was drafted in general terms, and 254 was more specific. So, and then they wanted to make it clear that we are taking all the labor powers from all the courts, because prior to that, state high courts had powers to take labor matters, some federal high courts. So they wanted to assume everything. And so that language of notwithstanding, and there's so many case laws as to the effect of that. So it's a bit of conflict in 251 and 254, but as we have it today, unfortunately, crew wages don't have the bite of arrest.
Yeah, which as far as I'm aware makes Nigeria the only country in the world where as far as I've seen, the only country in the world where it's not possible to arrest a ship in respect of crew wages.
Yeah, it'd be an anomaly. It'd be right out there. I'm not aware of any other jurisdiction like that. And And obviously in England, there's a clear right for an action in rem against the ship itself, in a maritime lien as recognised by English and Welsh law, and there's a straightforward jurisdiction. You have jurisdiction in the Admiralty Court. That's Section 22 of the Senior Courts Act 1981. It's a pretty standard type of claim. Indeed, under English law, where the defendant is the owner or bareboat charter of a ship, the seaman can actually arrest a sister ship in the defendant's ownership, and these are under sections 21.3 and 21.4.2 of the SCA 81. So, and you'll see similar provisions in jurisdictions around the world, and indeed that was effectively the position in Nigeria until this type of interpretation of its interaction with the NIC. So it's a fascinating one. I'm really glad that you've brought it to everyone's attention, Adi. And I had a question. In Nigeria, is there an amicus type process where on decisions, particularly those that are going up to, say, the Supreme Court, that industry bodies or other entities that might have an interest in the ultimate outcome can intervene and make submissions amicus curiae, either in support or against proceedings?
Yes, it used to be part of our jurisprudence, but it's not used anymore nowadays. But I know, like I mentioned earlier on, it's something that we are lobbying for, to express, to be able to have that in relation to the Court of Appeal, and in relation to the Supreme Court when they hear this case, because this will be the first case that I've actually gone up to that level. In recent times, there's another one involving the American P&I Club, and I understand that was stepped aside. They don't need to take it up, but I do know, and I hope that the Supreme Court will adopt amicus curiae in this regard. And you never know. We might invite you to give an English law perspective on this regard. I think it's very useful for courts to always have a history and not try to reinvent the wheel. We have a difference compared to the UK, whereby you don't have a specialized court that deals with just legal matters. And I think that's where the issue came about. I don't think it was an intent of the legislators to turn over hundreds of years of history on one case.
Fascinating. Yeah. It's not an atypical issue for Nigeria to deal with, the intersection between admiralty, jurisdiction, and labor laws. Most countries would have detailed labor law provisions which, confer jurisdiction on tribunals or courts to deal with those types of matters. So it's not like this is a unique issue that Nigeria alone deals with. And if there's the opportunity to provide English opinion on it, of course, be happy to assist in any way we can. Well, look, thank you very much for your time, Adi. I know it takes a lot of time to prepare for these things. It's a fascinating case. I can't think of a better case to have kicked off our kind of international broadening of our podcast. So we very much appreciate your time.
Thank you very much. It was a pleasure speaking to you. I think it's also a very good case. Like I said, it shows a diverse business jurisdiction in Nigeria. You have at least 4 or 5 jurisdictions related to this case before we even got to the Nigerian law aspect in regards to ownership and management and operation in Nigeria. And it's a pleasure to be on your podcast, and we look forward to other opportunities together. Thank you very much.
Appreciate it, Adi. Really enjoyed that.
Thank you very much. Until next time, we hope you enjoyed this episode. If you'd like to click and follow or subscribe our podcast on Spotify or Apple Podcasts, we'd be delighted to have you on the journey with us as we look at various commercial, maritime, commodities related and other types of legal cases around the world on a case-by-case basis.
Thanks, everybody.